I have seen every kind of person walk through that door. The frightened ones, the guilty ones, the ones who have rehearsed what they are going to say so many times that when they finally say it, it sounds like someone else talking. I have seen the ones who cry and the ones who refuse to and the ones who do not know yet that they are about to. But there is a particular kind of person that I have learned to recognize before they even reach the front of the room, a particular posture, a particular relationship with the space they are moving through. Lawyers carry it differently than anyone else. Not arrogance exactly, something more technical than arrogance. A professional confidence in their own understanding of the room. A belief that they know how this works because they have been in rooms like this before. That they understand the language and the procedure and the unspoken conventions, and that this understanding gives them an advantage. Sometimes it does. In other courtrooms, in other contexts, with other judges, that knowledge is genuinely useful. But there is something that legal training does not always teach and that some lawyers never learn. The difference between knowing how a room works and understanding what a room is for. Daniel Farrow was 34 years old. He had been practicing law for 8 years, corporate litigation primarily. The kind of work that happened in conference rooms and depositions and carefully managed processes where every word was anticipated and every outcome was negotiated before anyone sat down, he was good at it. You could tell from the way he moved that he was good at it. The particular economy of motion that came from years of being the most prepared person in the room. He had one citation, a moving violation, failure to yield at a pedestrian crossing on a Tuesday afternoon in October, the kind of citation that most people addressed in 10 minutes and moved on from. He had prepared for this the way he prepared for everything. I could see it in the folder he was carrying. Printed documents, organized, tabbed. I greeted him. He greeted me back with the courtesy of someone who respected the institution, if not quite the specific occupant of the bench. There is a difference, and I noticed it. I always notice it. I asked him about the citation. He said he wanted to begin by noting that the officer who had issued the citation had been positioned in a location that made it difficult to accurately assess whether a yield had occurred. He said the angle of observation was material to the question of what had actually been seen. He cited a case. He said it by name and jurisdiction with the ease of a person who expected that citations landed differently when they came with legal authority attached. I listened. I always listen completely before I speak. Not because I do not have things to say, but because the listening is part of the work. You learn more from how people explain themselves than from what they explain. When he finished, I asked him a question. I asked him whether he had yielded. He said the evidentiary record was not sufficient to establish that he had not yielded. I said that was an interesting answer. I said I had asked a different question. I asked him again. I asked him whether he had yielded. He said he believed he had come to an appropriate stop given the conditions at the intersection. I said I appreciated the precision. I said I was going to try one more time and I was going to ask him to answer as a person rather than as an attorney. I asked him whether he had seen the pedestrian before he entered the intersection. He paused. It was a brief pause, but I have been watching pauses for a long time, and I know the difference between the pause of a person thinking and the pause of a person deciding. He said he had become aware of the pedestrian as he was completing his entry into the intersection. I said so after you had already committed to the movement. He said that was one way to characterize it. I said I was curious how he would characterize it. He said he would characterize it as a situation where his response time was within normal parameters given the visibility conditions. I said I wanted to talk about something for a moment. I said I was not going to argue case law with him because this was not that kind of proceeding. I said traffic court was not appellate court, and the standards he was reaching for were not the standards that applied here. I said that what applied here was simpler than what he had prepared for. I said a pedestrian crossing was a pedestrian crossing. I said its purpose was not ambiguous. It was not subject to interpretation based on the angle of the observing officer or the visibility conditions or the response time parameters of the driver. I said its purpose was to give a person on foot a reasonable expectation that when they stepped off the curb, the vehicles around them would stop. I said that expectation was not a technicality. It was not a procedural requirement that could be challenged on evidentiary grounds. It was the entire point. He said he understood the purpose of pedestrian crossings. He said he was not disputing the purpose. He was disputing whether the citation accurately reflected what had occurred. I said I had a question for him. I said it was a genuine question, and I wanted him to answer it the way he would answer it to himself in a quiet moment. I asked him whether he would want his mother crossing that intersection. He looked at me. I said, I was asking because he had a mother. I was reasonably certain she was a person who walked places. I asked him whether he would want her to be the pedestrian in the scenario he was describing, the one where the driver became aware of her as he was completing his entry into the intersection. He was quiet, not the strategic quiet of a lawyer managing a deposition, a different quiet, the quiet of a person who had just had something that was abstract become specific. I said that pedestrian crossings were not designed for ideal conditions. They were designed for the full range of human inattention and human error, because human beings were inattentive and made errors, and the law understood this. I said the yield requirement existed precisely because drivers could not always see perfectly and pedestrians could not always move quickly, and the intersection of those two realities required a clear rule that did not depend on individual assessment of conditions. I said he had built a very elegant argument. I said it was genuinely well constructed, and I meant that without sarcasm. I said that in another room before another kind of proceeding. It might have been useful. But I said that the elegance of an argument was not the same as its truth. I said that lawyers sometimes forgot this. I said it was an occupational hazard. When you spent years constructing arguments, there was a risk that the argument became the thing you were interested in rather than what the argument was about. I said the citation was about a person who had a reasonable expectation of safety at a marked crossing and whether that expectation had been honored. I said the folder he was carrying did not change what had happened at that intersection on that Tuesday afternoon in October. He started to respond. I let him begin, and then I asked him to stop. I said I wanted to say one more thing before he continued. I said that I had watched lawyers come into this courtroom for many years. I said the ones who fared best were not the ones who came in most prepared. They were the ones who came in most honest. I said that preparation and honesty were not the same thing, and sometimes they were in direct opposition. I said a person who was honest with themselves about what had happened usually found that the conversation went faster and ended better than a person who had prepared an argument that required them to maintain a position they did not entirely believe. I asked him one final time. I said I was not asking for a legal characterization. I was not asking for a description of visibility conditions or response time parameters or evidentiary standards. I asked him whether he thought the pedestrian had felt safe. He was still for a long moment. Then he said no. He said, probably not. I said, probably. He said, no, no. He said, no. I said, thank you. I said that was the most useful thing he had said since he walked in. I fined him on the citation, full amount. I was precise and clear, and I gave him the same explanation I gave everyone, because he was standing in the same spot that everyone stood in, and the spot did not know what was in his folder. Before he stepped back, I told him something. I said that the law was a remarkable thing. I said it was one of the most sophisticated tools that human civilization had ever built for the purpose of living together without destroying each other. I said that was genuinely extraordinary. I said that people who understood it well were valuable and necessary, and the world needed them. But I said that the law was not the same as justice. I said the law was the architecture, and justice was what the architecture was supposed to house. I said that an argument could be legally sound and morally empty at the same time, and that knowing the difference between those two things was the most important skill a lawyer could have. Not the skill that was tested in law school, not the skill that won depositions, the skill that determined whether a person spent their career using the law to get to the truth or using the law to avoid it. I said I hoped he was the kind of lawyer who knew the difference. I said the pedestrian at that crossing was hoping for the same thing. He paid the fine. He walked back through the gallery without the folder open. He carried it at his side. Something in the way he carried it was different from the way he had been carrying it when he walked in. It was the same folder. It weighed the same. But something about it had changed. I moved to the next case. That is what you do. But I thought about him for a moment longer than usual, not because of the citation, because of the pause. The brief pause between my question and his answer when he was deciding what kind of person he was going to be in that moment, those pauses were where everything important happened. Not the arguments, not the citations, the pauses. See you in the next one.